Let's shift focus to another big story that we are tracking through the day today. Now, the Supreme Court has deferred the hearing on the constitutional validity of the sedition law till Tuesday, when it will now decide if the matter needs to be referred to a larger bench. The top court has granted the last opportunity to the central government to file its response by Monday morning. And this has happened after the central government did not file its response on the sedition law today, stating that the draft needs to be approved by a competent authority. Now, during the hearing today, the top court also asked the centre to give its prima facie view in connection with the law. The central government, in response, said that the matter will have to be discussed between the government and legal advisors. Now, to actually talk about this entire debate of the validity of the age-old colonial sedition law, I am joined on the broadcast by senior advocate Colin Gonsalves, who's joining me, on Mirror now to actually take us through about this entire furor on the sedition law, and also the government really taking its own sweet time about defining what it really will brand a person as anti-national with. Mr. Gonsalves, thank you so much for joining me on the broadcast. First things first, what do you have to say about the kind of time that the government really is taking when it comes to defining anti-national as per them?
Well, today what the government said was that the Kedarnath judgment, which is most unsatisfactory in some ways, is all right. So they don't want to change in the status quo. And I can understand why, because Kedarnath said, there were two things, one good, one bad. Kedarnath said, you can't have sedition without violence. But what Kedarnath failed to do is it should have removed it from the statute book. Instead, it gave a kind of advice, a kind of a reading down that you must have violence. It's kind of advice to the police and to the country. But no policeman is going to read a Supreme Court judgment. A policeman is going to look at the IPC, the Indian Penal Code. And it remains on the Indian Penal Code, and the words are such that even strong words against the government is sedition. Kedarnath said no, but when you look at the IPC, it says strong words are enough. And that is the reason why you have a proliferation of thousands of cases across the country. It's sad that the central government wants to maintain that status quo, but I can understand they want to stop all kinds of protests. Even when you use strong words against the government, sedition. But that's not the way it is at all. And the Supreme Court says that's not the way it is. You must have violence following words.
Absolutely. Mr. Gonsalves, those are very strong points. And of course, I'd like to understand your own views on this colonial practice of still continuing with the sedition law in the country. There has been so much said about entire, the government of India trying to muzzle dissent and not really giving that voice to anybody who has a differing opinion. You have pretty much, summed up what you feel about that. But however, having said that, if we actually talk about the validity of this particular law, how does it really stand in 2022?
Well, it's obsolete. And the country from which we got it, that is to say, the UK, has abolished it decades ago. And you have in India after that, why we say it's obsolete, is because the Kedarnath judgment was somewhere in the 60s. After that, you brought in UAPA, which is the most pernicious legislation you can have on violence against the state. So now when you have UAPA, why do you want sedition? And the answer to that is the statute sedition says words against the government is enough for sedition, which means it's contrary to freedom of speech and expression. And in Rangarajan's case, the Supreme Court said, even things that are hateful to the state. Can you imagine? Hateful to the state. I hate the government. I hate this politician. I detest their policies. Even things that are hateful to the state is part of freedom of speech and expression. So you can understand the government. The government wants to punish people for words.
Right. And Mr. Gonsalves, before I let you go, the top court, in fact, prima facie wanted to know, what is the centre's view when it is about sedition. They, in fact, still did not come up with an answer. What are your views about how did the Solicitor General really put forth, his petition to be granted more time so that centre can actually define and respond to the pleas that challenge, the validity of sedition law in the country?
Well, today, as I could make out, I could be wrong, but as I could make out, the Solicitor General was asking for time because it's a complicated issue and he wanted time to put his position there, which fair enough. But the Attorney General went ahead and said that he feels Kedarnath is a well-reasoned judgment and that Kedarnath should not be interfered with, and that he was saying that there's really no reason to give it to a larger strength of judges, from 5 to 7 or 9. No reason, he said. Kedarnath is the final end of everything. It's perfect, which is what was a little unexpected because the Attorney General, I mean, he represents the government, but he's a very learned man in many ways. So we were a little disappointed.
All right. Okay. All right, Mr. Colin Gonsalves, thank you so much for joining me on the broadcast and taking us through what you actually feel about not just the sedition law, but also how and where, is the government and also really the court is headed when it comes to actually coming up with, ample answers on the kind of debate that this entire law, which is still in practice in the country, has in fact garnered.